Welcome back to yet another monthly presentation on our tour de force on employment law in Australia. Today we are going to get down into the detail and look at some quite specific rights that employees have been afforded by the Commonwealth Government, in particular the current Labor government, during their recent tenure, that have codified a greater degree of flexibility for workers within the workplace. The implication of that from employers is unfortunately just the word complexity. So for a lot of employers, it's just created more uncertainty. At an overall level, what it's done, in my view, is once upon a time work sites were somewhat homogenous. People tended to work fixed hours and in a particular place. So people would come into the office between 8:30 and 5, and then everyone would go home, and some may work back a little bit, or people would go into the shop floor, etc. But now, increasingly, due to changes in technology, there has afforded businesses and employees the opportunity for employees to carry out their duties in places other than the workplace. And so what we've now got is a series of rights which have allowed employees to say, listen, I want to be treated differently than other people for my own personal circumstances, and I want to negotiate with you a new way of working. And so you could have a workplace over time where, say, 20% of the workforce would be working under different arrangements than the rest. And this has implications for workplaces going forward. It's not going to go back to where it was, and so we'll all have to sort of get used to that and get across these particular rights and make sure that they don't get tripped up. Now, I'm in an unfortunate situation in that under the current technological arrangements, I can just see the PowerPoint screen. I actually can't see anything else, so I don't know who's online or who's putting their hand up. I've got today with me, I've got Alex, who is my senior associate here at Hickson's in our workplace relations team, and she will be doing a part of the presentation in relation to parental leave for reasons she may share with you that are close to home, but towards the end of the presentation. And also she will handle the Q&A at the end. So it's currently 12:05. My aim is to get through this within about half an hour or so, and then leave time for Alex, and then also for some questions at the end. Okay, so just to sort of remind you where we've travelled and where we're travelling over the course of this year. We started off 3 months ago looking at the Fair Work Act, and also in relation to awards, and we highlighted there the particular requirements that are attached to adhering to both awards and the Fair Work Act, and the implications if you don't, that and we will be talking about this today, that you can end up in a situation where there's a breach which leads to a penalty. So it's not just compensation, there's an actual penalty that's attached to it. And we looked at various aspects of the way awards work and coverage, etc. And then we looked at employment contracts and policies and how they are different, and how employment contracts really do require an agreement between two parties, and that they can't be changed at the whim of one party, whilst a policy can be changed at the whim of an employer, often maybe with some consultation, but they're entitled to change policies. And the implications of a breach of a contract is there may be damages attached to it, whilst the breaches of policies generally just relate to disciplinary matters that may arise in relation to breaching a policy, or if an employer breaches one of their policies, it can have other implications, perhaps for discrimination or maybe workers' compensation or even work health and safety. Now, as I said, we're going to look at some specific rights under the Fair Work Act that we didn't deal with on the first occasion, and how employers are obliged to respond to them. And in particular, I will be looking at it in the context of the help portal that we have developed to enable employers to step through and deal with these issues as they arrive in real time, whenever you want. And the beauty of the portal is it's up to date and compliant, and it's available whenever you want, and it takes you through all of this. And I'll give a bit of a you'll see that play out in today's presentation. So what are these rights? Well, we're going to be looking at flexible working arrangements and which afford most employees, and there's criteria attached to it, but as you'll see, it'll cover most employees, giving them the right to make requests to work different patterns of work than other people within the workplace. And also that includes different locations. And the right to disconnect. Now, this is an interesting one because the right to disconnect is really a product of the intrusion of the internet into our lives. And for many employees, they can now theoretically carry out their duties or be asked to carry out their duties from home. If you've got a laptop and you're working as a content writer for in a business, then you can kind of theoretically work anywhere. So the right to disconnect and arguably be asked, and by working anywhere and be able to work at home, it means that employers have got greater flexibility to intrude on space outside of your work hours. So what does that look like, and what rights have employers got to say no? In some respects, they are an interesting polarity, because on the one hand, you've got people saying, and this is often the case, actually, under flexible working arrangements, what I'd like to do is I want to stop work at 3:30 in the afternoon, so I can go and pick up my kids from after school care at 4:30, and I want to go home and then cook dinner for them and help them with their homework and arrange for them to be put to bed. And then at 8 o'clock, I'll sit back down and I will log back on and do some more work. So that is working, and that's work from home out in the evening. The right to disconnect is actually the opposite in some respects. It's employees saying, hey, listen, I do my hours from 8:30 till 5:30, and maybe I don't mind doing a bit of overtime, but I don't want to be sent an email at 9:30 at night and asked to respond to it. So I'm actually exercising my right to disconnect for work after 6 p.m. at night. So it's a difficult thing for employers, because you've got arguably employees exercising rights going in the opposite direction to one another. The other rights we're looking at are public holidays. An interesting case arose there where that came out of a High Court case a bit over a year ago, and where the rights of an employer to demand that employees work on public holidays was tested. And out of that, we've got some clarity as to how you can require people to work on public holidays. Another one which catches a lot of employers off guard a little bit is the end of year shutdown. I mean, most businesses, if they don't shut down, they may go on a skeleton staff. If they're not in retail, it's often around Christmas. Sometimes at other times, because there may be some sort of maintenance done on a facility, and they have to shut down that portion of the business, or shut down the entire business for a week or so. And so a number of the staff won't be needed. So how does that work? Can you tell a employee not to come to work and not pay them? Because the general position is someone is full-time, they are entitled to be paid unless they're on, and indeed to kind of work or to be available to work. Whether you choose to give them work is another matter, but that's the nature of permanent employment, whether it's full-time or part-time. When they're rostered on, then they're rostered on. So how does it work when a business wants to say, actually, we don't want you for a period of 10 days or 2 weeks in the case of some businesses over Christmas? And then there's casual conversion. And that's, as we looked at earlier, what looks like a casual arrangement and what is a permanent arrangement. And the right now for employees, after 12 months for a large, after 6 months for a larger business, 12 months for a smaller, to stick up their hand and say, actually, I want to be a permanent employee. And then Alex will take us through the complexities of the parental leave. And then I'm just going to look at additional rights, but some other ones thereafter. So starting with flexible work arrangements. Sorry, no, actually, before I go on with that, and I should be able to look ahead with my slides, but why do we care about complying with the processes that are attached to each of these rights? Because each of these rights actually has a very specific process attached to it. And what are the implications if we don't follow them? Well, the first implication is that they are obligations that are imposed upon us. So if an employee goes to exercise that right, and we don't like that, and as a result, we don't follow it and maybe actually treat that employee in a way that's adverse to them. And that can come in many different forms. It can be maybe the allocation of shifts. It may be the availability of overtime, or obviously it may be even a disciplinary matter. That can give rise to a range of other obligations, other rights, such as general protections, or it could be even give rise to an unfair dismissal. For example, if you did not comply with your obligations in relation to a flexible working arrangement, and the employee was left in a position that they had no alternative but to resign, they could potentially say it was constructive dismissal and run along those lines. Or it's a person with a disability that needs certain flexibility, and the employer doesn't follow the process and adhere to their obligations in relation to this flexible working arrangement, then it could give rise to a discrimination claim. And in certain limited circumstances, although less so now, if you don't comply with the process, it can give rise to a workers' compensation claim. But in our view, actually, there's greater opportunities for defending such a claim if you do comply than it previously existed. So I'll talk a little bit about that. Probably the main reason is these are rights that are where if there's non-compliance, then they give rise to what's called a civil remedy provision. And for many of these breaches, they attract a civil penalty. Now, a civil penalty for a business, for a larger business, well, actually, for not a small business, I should say, and that's not very big, that's just more than 50 employees. We're talking about fines of $500,000 and nearly $10 million, $5.5 million in the case of a serious contravention. And these penalties are paid to the worker. That is that's the attractive aspect for it. If an employee seeks to run this, or if a union decides to take up action on behalf of employees, then the union can ask for that civil penalty to be paid to the union. So it makes it an attractive prospect for employees to run. So that's the reasons we say that these are matters to be taken seriously. There is, it is important to get it right and to respond appropriately. Otherwise, there are a range of remedies available to the employee to enforce this. So the first of them we're going to look at is the flexible working arrangements. So to be eligible for it, you've got to be work for at least 12 months. And you've got to meet certain criteria which relate to whether you, and I'll take you through those, but essentially, and they are whether you are pregnant, you have parental or caring responsibilities, you have a disability, or you're caring for someone with a disability, you're 55 years or older, or you're experiencing domestic violence, or you're caring for someone who is. And that's a large slab of the workplace. Just a number of people who are parents or in an aging workplace, so people over 55. Number of people, obviously people who are pregnant, but also number of people with disabilities and range forms, which could be psychological disabilities. So I'd probably say most of the workplace in many, or most of the staff in many workplaces would be entitled to make a request for a flexible working arrangement. So the requests must be in writing. If you want to accept a request, you can. But if you don't want to accept the request as it's made, then you must discuss that with the employees. You cannot simply refuse. Then there is an obligation to put in a response within 21 days, setting out the reasons for your refusal. And those reasons must be based on reasonable business grounds. And you must actually go beyond, you must explain how those grounds apply to their specific request. So the way we have so when we use this in help, it asks us a series of questions. Is the employee's request for working arrangements, is it verbal or if it's written? Because if someone gives a verbal request, then there's actually not an obligation to, that doesn't initiate the process. So at that point, we recommend that that you simply write to them or let them know that the request has not been properly made. If the under our help portal, we take you through this process, and we then ask that if the request is made, the first question is, have you met with the worker? And if you haven't met with the worker, do you want to vary or refuse the request? And if you do, then the portal will send you back because to refuse it, you've got to first meet with the worker. So if indeed, and then so if you have if you do want to make, so if you do want to refuse, then you've got to meet with the worker. So we ask you that question. It asks you whether you want us to write, draft a letter for you. And then you move through, and it will draft that letter to the employee, inviting them to a meeting. So that's the first process. It has to be, the request has to be in writing. If you don't want to agree with their request as it is, you want to vary it or refuse it, then you've got to meet. So you've got to make that arrangement, and hence the letter. If indeed you do then go ahead and meet with the worker and discuss their request, then the help portal, it will ask you when you log back on after that, did you meet with them? Yes, on such and such a date. How would you like to proceed? It gives you various options, including refusing, which you can do. And then if you refuse, then in that case, we just give you a bit of a checklist to say, just to make sure, if you are going to refuse, have you discussed the request with the employee? And have you genuinely tried to reach agreement? Because that's the obligation under the legislation. And have you considered the consequences for the employee of refusing? Again, an obligation under the legislation for refusing the request. If you have, then you can proceed. So if you followed the correct procedure, then at that point, you've got to ask yourself, what are the grounds going to be the grounds? Well, what are the grounds for refusing? The costs must be, the arrangement might be too costly. It would be impractical to change working arrangements. So how could the arrangement be too costly? Well, one of the issues could be that they may want to be doing work on a Sunday, and for example, and the award requires that people be paid double time on a Sunday. So that's not going to work for you if you've got to pay someone higher hourly rates to be working on a Sunday when they could otherwise work on midweek. So that would be a circumstance where the cost would be too high. Or it may mean that they've got to do their job, they've got to work with other people. And so if they want to work in a different way or out of hours, it actually requires other people to be available. And generally speaking, those people are not available. So you would actually have to pay for other staff to work overtime. That would be an example. It'd be impractical to change working arrangements. That may be, for example, you're under a contract with a client, and that contract has particularly restrictive circumstance or obligations upon you, and so it's impractical. You can't do that. The requirement would require additional hiring. So a good example of that may be, for example, if someone wants to leave to pick up children at 3 o'clock, then because the office has to remain open till 5 o'clock, you need someone in that office to cover, because the person may have actually done work, but they've been sitting, for example, at reception, or they've been they've been servicing the front desk, and you're not going to have adequate people there, so you'd actually have to get a casual in to cover. And even though they might do the other aspect of their duties, which will be computer related at home at night, you've got to fill that role. So that would be the cost of additional hiring. It can be efficiency. Maybe people work in teams and they work really efficiently together when they're working together. And if you have someone working different hours or in an isolated location, then that efficiency is not available. That can often come up in circumstances where we're talking about working from home. Because one of the arguments about working from home is that you often get good teamwork and you get a transition of skills from more experienced people to less experienced people. And so having less experienced people working from home, say 3 or 4 days a week and only coming in, you're not going to get that transition of skills. And then, of course, there is customer service. So they're the examples of where it works. If you want to refuse it, then following our flexible work request, you would just skip to which of those you're going to follow, and then you would insert the answer and follow it through to completing the details for the letter, and then you will end up with the response that you will send to the worker who made the request. So that's your flexible working requests or flexible working arrangements. And there's your correspondence there. So with the right to disconnect, I won't take you through the details because it's a sort of similar as far as help is concerned, but that gave you a flavour of how the portal allows you to respond to these requests in a lawful way. And we put a lot of time and effort into making sure that that's compliant, and we update the back end every day to make sure that there's change of legislation so you're not caught out. So yeah, that took you through. That's the process for flexible arrangements. The right to disconnect is that's a right, as I said, that is really a product of employees in many roles being able to be accessed by their employers after hours. It's often very common that you would have employers where an employee may want, an employer may be a subsidiary of an overseas company, and so you're going to. It's common that they might have meetings at sort of 10 o'clock at night or 6 o'clock in the morning. And so these are the requests that can come in, and some employees may decide that they do not want to be part of that, and they do not want to be getting up at 2 o'clock in the staying up till 10 at night to attend to meetings. So they've got a legal right to refuse. The question is whether it's unreasonable for that refusal. So what does that look like? Why was the contact made after hours? So is it a reasonable request? How disruptive it is for the employee, and it may come in at a time when the employee, for example, is settling their kids. So it doesn't work easily in that respect. Another question is, are they compensated for it? And what is the role and responsibility? Are they senior? It's more likely where someone is in a senior role and on a salary where they're being paid a reasonable amount of money that they could say, well, actually, it's quite reasonable for us to request that you be available 2 or 3 nights a week to respond. And it does bear on the individual circumstances of the employee. That really does have a bearing on it. So, how do we deal with this as employers? I think one of the issues that you might want to look at is your contracts and even how people are compensated. If people are willing to be available to work, to log on for meetings at 10:30 at night on a regular basis through to midnight and be front up, then they really should be entitled to be paid extra money. It may be within a contract that you actually compartmentalise the remuneration so that people are paid a certain amount of money on certain bases, and if they're going to be requested to attend on a regular basis later meetings, that in fact they be paid an additional amount of money, whether it's a salary or in some other form. That could be a way in which you compensated the employee from the beginning. Also, if you notify the employee in the beginning that that's what you want, and you've compensated them appropriately, that puts the employer in a much better position. Now, with the individual circumstances, that's where it gets a bit interesting, because some employers would say, listen, we've got a right to request someone to work reasonable overtime. That's under the legislation. That's one of the NES. So what is reasonable overtime? For an employee who's maybe been paid $160,000 a year, it might be reasonable that they're working back till 6 or 7 at night. 6:30 or 7 o'clock at night. And so maybe the employer could just say, listen, that's a reasonable request. We're entitled to do that. Now, the employee may then want to say, okay, well, if that's the case, it's maybe a request for flexible work arrangements. So I can't do that, but I can work later at night. So I can work in a different way. And that's this is where you're going to get two rights that run headlong into one another, whether the reasonable additional hours and the right to disconnect, they sort of push in the opposite direction. And that is really going to depend a lot about the compensation, the seniority of the role, the way their job description is set out and how that describes the scope of their work, and how they are compensated. Either the amount of compensation they receive, or maybe they're compensated, as I said, in a way that kind of is compartmentalized, where there's a certain amount set aside if they are available to work after hours, as it were, into, sort of 7, 8, 9, even 10 o'clock at night. So that would be a basis for a refusal. Okay, so there's your two. They're two big ones that have come on the scene. Our experience is that they have not been really accessed by employees in a way that when they came on the scene, when the first legislation came through a couple of years ago, the right to disconnect, there was a lot of publicity about it. Employees were very concerned about it, and yet the employees haven't really accessed it so much. My general view on this is that employees take a while to become aware of their rights, and also their advisors, including employment lawyers and unions and what have you, they take a while to kind of default. When unfair dismissal arose, it took a little while before it was got to the levels that we're at. When the right to make claims for psychological injury arose in workers' comp, that took a number of years before it became a regular, and nothing like, and many, many years till it became what it is now. So I think that over time, the right to disconnect and the flexible working arrangements are going to be increasingly accessed by employees, and it's important that you follow the process, because it's so annoying if you get brought undone by a process, and you maybe think you're being entirely reasonable in your reaction, but if you haven't followed the process, suddenly the employee's got the right to go to the federal court and have one of these penalties imposed upon the business. And that's and theoretically, even upon one of the members of management, a lesser fine, but still a fine. So it's important to follow the process, and hence the help modules helps, the portal helps you step through it to make sure you get it right. So the next one we're going to look at and skip through is this question of public holidays. There's not an inherent right to request an employee to work on a public holiday. Public holidays are part of the NES, that is the National Employment Standards. We discussed National Employment Standards when we talked about the Fair Work Act. They're mandatory standards that apply to all employees, whether they're the CEO of BHP down to the lowliest, junior retail worker working at Coles. Everyone enjoys these rights. So public holidays are to be respected in that regard. Now, for just a little thing, for non-working, so what is a compensation? There's generally, if you're a award-covered employee, and we talked about award coverage, it's a bit surprising. It can cover all sorts of people at times. For not-for-profits, it often can cover CEOs, and it can cover engineers on $200,000 or $300,000 a year. So if you're covered by an award, generally there is an obligation to pay at least double time, if not 2.5 times, if you're going to make someone work on a public holiday. That's the statutory rate or the award rate. Now, if you're going to request them, it must be a reasonable request. You cannot demand that someone work on a public holiday. And if they don't do that, just be aware, if you treat them afterwards poorly, and it may mean, ironically, it may mean that you don't offer them the opportunity to work on a public holiday in the future. That could be an adverse action. It can be many forms. It could be just you snarl at them a lot. That could be adverse action if they say, I don't want to work on a public holiday. Comes up a lot around Christmas. You've got shift rosters, particularly for enterprises, retail, hospitality that work over Christmas and New Year. Often people don't want to work on Christmas Day, and there's a contest around that. So if you treat people badly as a result, then there's adverse action. Now, public holidays are gazetted by states on obviously there's commonality around Christmas Day and New Year's Day and Anzac Day, but Labor Day is different in different states, for example. So with public holidays, now, just in relation, what I didn't mention, if they're a non-award employee, there's not a lot of non-award employees who are wage earners, but if for whatever reason they are, then there's no obligation to pay penalty rates as such. But that may impact upon the right or the reasonableness of an employee to refuse to attend work on that public holiday if he made that request. So how do we handle this in the portal? Well, we are having made, it takes you through the process and asks you, when this public holiday's the date of it, and then it says, what's the reason why? Because you've got to give a reason. It's got to be a reasonable reason as to why you're requiring them to work on a public holiday. Having inserted that reason, it will then say, ask you some other questions. They can work different hours. Will they be entitled to penalty rates? And then based on those answers, it will provide a letter to the employee asking that you requesting that the individual be available to work on the public holiday. So the refusal, what's reasonable grounds for making the demand, and indeed the opposite for refusing, reasonable grounds for refusing. For making the request, the operational requirements, and some workplaces just need to operate. And obviously, hospitality can be even busier on public holidays than other times of the year, especially around Christmas. The personal circumstances of the individual and what their responsibilities are. Whether the employer, in that role, would you normally require them to work on a public holiday, or is that an odd thing? It would be an odd thing in a law firm, for example, for us to demand that they work on a public holiday. The entitlement compensation, as I said, if they're going to be paid more for it, their type of employment. So with a casual employees are entitled to refuse to work shifts, but permanent employees, if they're rostered on that day, normally, if they're a part-time employee and they're not rostered on that day, and you're asking them to work, then you're really asking them to work overtime. It's not part of their rostered hours. If they're full-time, it's different. And also another basis for it is the advance notice you have. Is this a last-minute thing, or did you give them, a month's notice ahead of time? Okay, another request that people make and get terribly wrong. We looked at, as I discussed, at the end of it's often the end of year shutdown. It can be anywhere time, but now if you don't get this right, it can cause a lot of grief. Now, there is, for non-award employees, there's a fairly general right to make this request. It's not specific, it's not as detailed, and it's set out in the Fair Work Act. Now, the way and if you don't follow the process, then if you're not compliant, and then can insist on coming to work. Or if you want them to stay off work, you can't require them to take annual leave. You would have to pay them just money to sit at home. So that's, with this case, it's very important that employers get this right. So first of all, see whether they're covered by an award, and if they are, you need to identify the reason, the right to request, and it's generally under an award. There has to be written notice given. You'll need to better understand the employee's leave balances, because it makes it a lot easier if they've got accrued annual leave. And you might even want to suggest to employees that they retain annual leave for the shutdown. And you've got to account for public holidays, because they don't account in the process. So as we follow this through using the portals, we ask all those questions. Firstly, check whether it got an award coverage. If they do, then there's actually a process sitting out under the annual leave clause of the award, which sets it all out, and it's common to almost all awards. So check your award under the annual leave section, and it sets out what the obligation is. Now, the key thing is you've got to have given 28 days written notice of the shutdown. If you don't do that, then you're non-compliant, and that can cause a lot of grief for an employer. It could mean you effectively pay them everyone an extra week's leave. Then you've got to set out the reasons. So, for example, I've inserted there that they're moving premises, which requires the business to be shut down, apart from skeleton staff. And then they'll set out that the annual leave. Now, in some cases, people won't have enough annual leave accrued to cover the period. So you ask them, how do you want to cover it? And they might say, well, leave without pay. Now, they might say they want to work during the shutdown because they can't afford to take the time off. Now, let's just say, I'll circle back to that, but if it's annual leave or leave without pay, that's fine. So you can direct someone to take annual leave, and you can ask them to take leave without pay. Now, if you do that, you'll end up with this letter to them, which is telling them that they are required to take the place will be shutting, the work will be shutting down. They're required to take leave. So now, one of the problems with this is if people don't have adequate annual leave and they do not want to take leave without pay, because that can only be done by agreement, arguably they have a right to work during that period. That can cause all sorts of headaches. Okay, so casual and conversion. We talked about what casual employment is on the last occasion. Earlier on. It's basically there's an eligibility to make it, to make this request to convert 6 or 12 months, depending on the businesses. Is the employee able to offer ongoing work? Does the employer have the ability? The employer have the ability of the employee to accept or reject work? Does the employee have a regular pattern of work? So if they have a regular pattern of work, then really it's going to be hard to resist the request. And is it likely there will be future work available for the employee? And you'll see as we look through this that that's one of the reasons. Once a request is made, 21 days. If you don't do that, you're in, and bang, you're in penalty territory, and also various other breaches that the employer could, the employer might jump on it, and if it's repeated, suggest that it's to do with some form of bullying. And if people make this request, you can't treat them adversely, you can't manipulate, you can refuse on operational grounds, and if they do convert, you want to change their contract to a permanent one. The portal deals with all of this. I won't go in chapter and verse all the way through, but it takes you through the process and asks you, for example, when they convert, are they going to be full-time or part-time? And then it continues to ask you various questions, whether you're a small or a large business, because that's got to do with the amount of time that they need to have worked there. And then it asks you some key questions before responding in writing. You must meet with the employee to discuss. So the questions, if you have to sit down with the employee and have a conversation with them before you make that decision, particularly if you want to refuse that. And then you've got to go through and you've got to set out the reasons why you are going to refuse to respond. So there's a range of things you need to, and we set that in the portal. We make suggestions as to both the nature of the current arrangements and what you must need to take into consideration when you are deciding whether or not to allow them to convert to permanent. Now, there are 3 basic grounds that the employee still meets the casual employment. So it's not really a permanent part-time role. There are operational reasons for not accepting it. And that if accepting it wouldn't be complying with a less common recruitment or selection. I won't dwell on that. But in relation to it may be that their work really is continues to be casual, and they're not working on a regular basis. So their request for working arrangements, to go on as a permanent employee just doesn't stack up, because their pattern of work just doesn't really meet that definition. And then we provide a response. In this case, the response I put in was that, taking into account the real substance and practical reality and the true nature of the employment relationship, PaintCode has found that your current employment still meets the definition of casual employee. There's no firm advance commitment to continuing work. And we say, you've been doing a number of shifts while we've been recruiting a full-time employee, and also while your colleague has been on maternity leave, that indicating that that's going to come to an end soon, which means it doesn't justify permanent employment. Okay, so we're now going to talk, I'm going to hand over to Alex, and just to get a change in tone, and we're going to talk about parental leave. Alex.
Oh, I just in classic form, I just said my first few sentences on mute. Let me start again. Thank you, Warwick. I am going to speak to you for the next few minutes about some of the curlier issues that can arise when an employee wants to take parental leave, or issues that can arise both during parental leave and when it's coming to an end. So under the National Employment Standards, employees, including regular casual employees, with at least 12 months of continuous service, are entitled to take up to 12 months of unpaid parental leave if they have responsibility for the care of the child. There can be a misconception about this entitlement, that the employee needs to be the primary carer of the child in order to receive the benefit. That's incorrect. What the employee actually requires is to have responsibility for the care of the child, meaning they could have a partner at home sharing care for the child and they would still be entitled to this benefit. So the entitlement under the NES is for unpaid leave, and it operates separately to government-funded parental leave pay, a completely separate issue that's not enshrined in the Fair Work Act, and is also completely separate to employer-funded leave, which may be afforded under a policy or perhaps under an enterprise agreement. The distinction in the National Employment Standards that an employee is entitled to parental leave if they have care for the child, not primary care, can become relevant if you are considering implementing additional entitlements in your workforce for paid parental leave, such as under a policy, and you are tying those paid entitlements to the employee's entitlements under the Fair Work Act. So you may need to pay some special attention to how and when that employee receives that paid entitlement. A person is entitled to unpaid parental leave if they or their spouse or de facto partner give birth or adopt a child under the age of 16. So it's not just for those newborn babies. And parental leave more recently has also extended to parents or caregivers who experience a stillbirth or the death of an infant within the first 2 years of that infant's life. Parental leave can be taken in a continuous period, which is the parental leave that we all know and are familiar with. And more recently, it's also changed so that employees can take parental leave flexibly, which could look like working reduced days each week and then taking some days as parental leave, or taking parental leave in chunks over time and then coming back to work in between those chunks, or a combination of the both. And the number of days that an employee can take flexibly has increased incrementally each year over the last few years. Now, If the date of birth or placement of the child is after the 1st of July, the employee can take 130 days of flexible unpaid parental leave. An employee can also request a further 12 months of leave, and that request needs to be submitted in writing no less than 4 weeks prior to their planned parental leave ending. It's important to note that an employee has a right to request the parental leave, but they don't necessarily have a right to it being accepted. So there can be some discretion there about whether an employer rejects that or not, depending on what they've got going on in their workforce at the time. New slide, Warwick. Oh, Warwick, can you go to the next slide?
Yeah.
Oh, there we go. Thank you.
Sorry, my computer's a bit slow.
No problem. All right, so let's jump to the stage where an employee is on parental leave. Ordinarily, an employer only has to consult with an employee about, quote, major changes in their workforce, so potentially major changes to that employee's role, or if the employee's, if that role could potentially be removed from the organisation. If it's imposed by a modern award or an enterprise agreement, that covers that employee's employment. However, there is an additional obligation in the Fair Work Act to consult with any employee on parental leave. If an employer makes a decision that will have a significant effect on the status, pay, or location of the employee's parental leave position. So this obligation applies regardless of whether the employee is covered by a modern award or an enterprise agreement, or if they're paid above the high income threshold. So in which case, let's say that an employer has made that decision, they have to take all reasonable steps to give the employee information about and an opportunity to discuss the effect of the decision on that position. So for example, if an employee's parental leave, pre-parental leave position has evolved over the course of their leave so that the scope of their role has changed, and therefore perhaps the role status has moved up in the hierarchy, has moved down, these consultation obligations would apply. Or if an employer is aware nearing the start of an employee's parental leave that their role has been made redundant, it no longer exists, but they don't start consulting with that employee until nearing the end of their parental leave when they're anticipating the employee returning, that could be a breach of the Fair Work Act, and it could give rise to a claim for penalties, regardless of whether that employee has a right to bring an unfair dismissal claim. So in that case, the employee could argue that they were disadvantaged by not being consulted earlier, because if they had started that consultation earlier, maybe they could have spent more time actively trying to find a role for when they plan to return to the workforce after parental leave. Let's assume that hasn't happened, and we are getting near the end of the parental leave and the employee is expecting to return to work. They are entitled to return to their pre-parental leave position, or if that doesn't exist anymore, another available position for which they are qualified and suited, which is nearest in status and pay to their original role. So again, that obligation applies regardless of whether they are above or below the high income threshold. What's really important to note here is that these entitlements that are enshrined in the Fair Work Act for employees that are on parental leave and returning from parental leave only apply if they were actually entitled to the parental leave in the first place. So, for example, if an employee had not been continuously employed for 12 months at the time that they're planning to take that parental leave, that employee is essentially on leave without pay at that time. And for some employers, this isn't a problem. The employer will still recognise it as parental leave. They'll still hold the employee's role open and everyone carries on. For other employers, this could be a real problem. They don't want to hold that role open for the employee. And that employee is essentially on some form of unapproved leave for the period that they're not at work, which can give a basis for an employer to terminate an employee's employment. So this can be a highly contentious area of law to deal with, but the problem does arise. Now I'm going to pass back to Warwick for the last couple of minutes, and also just flagging that we have still got a couple of minutes left for questions. So if you have any questions for us, then feel free to put it in the Q&A.
Thank you, Alex. Okay, it's actually additional rights that's a misnomer. It's actually just one, and I just want to draw your attention to fixed term contracts. By and large, one of the changes from a couple of years ago was that fixed term contracts have now been capped at 2 years. This applies whether it's a series of fixed term contracts or indeed the person may well have been employed full time in a role, and then that came to an end, and you put them on a fixed term contract for a year. The cumulative nature of the employment cannot be more than 2 years. There's some exceptions particularly for not-for-profits and for some educational institutions where there's funding tied to roles, but just don't bear all of that in mind as you're considering the nature of employment. It's important to get your head around in relation to your employment, because again, if you do it incorrectly, a penalty, one of these civil penalties, can arise, and increasingly you're going to find some of these unfair dismissal kind of outfits are going to be running these claims based on penalties, and certainly unions don't hesitate in running a claim like that. Now we're creeping up to the hour. I will do a little bit of a call to action here if I can. That's as I'm told that's the thing to do at the end of the presentation. We have developed help for the benefit of businesses. What it does is it enables you to handle all these requests, and to do so in a seamless way. It gives you all the information you need on the way through to make a decision, and it gives you the documentation. It means that you can be compliant, and I cannot tell you how important that is. Now, what we do is we make this available to businesses on a subscription, and it's very modest subscription, monthly subscription for businesses. But what it does, but it enables people who may not be experts in HR, and that's probably most of us. Well, not so much me, but most of you who are not experts in all aspects of employment law, to be comfortable that what you're doing is compliant. Now, Alex, do we have any questions at all arising out of the presentation, or shall we do a close?
No, we don't. We've actually finished bang on at 1 o'clock as well.
Obviously, we've provided all the information. Please reach out to Alex or myself or Yoni in relation to, if you're interested in having a demonstration of the portal. We'd love to show it to you. And it's I think it's a no-brainer to at least have a look at it and see what benefit it could be to your business, because we think it's absolutely terrific, and it's really one of a kind available at the moment. It's an online law firm, or more particularly an online employment law firm. Okay, thanks very much, and we'll meet again in a month's time. Thank you.
Bye.